The Bush administration says there have been no terrorist attacks on the United States since 9/11 because of the measures it has taken, including the powers it acquired under the Patriot Act. Those powers increase the ability of the FBI and intelligence services to examine phone records, emails, and library records. Congressional critics have raised questions about threats to civil liberties if such powers were abused, and some were modified under a reauthorization of the Patriot Act. Then suddenly in March, FBI Director Robert Mueller announced that in fact the Bureau had misused the act to obtain thousands of personal records without prior judicial approval. Specifically, Mueller mentioned thousands of national security letters, a little-known tool used to obtain information without traditional search warrants. Such letters figure prominently in our next report, which examines whether we're sacrificing civil liberties for security.
Right here in the Oval Office, I get briefed nearly every morning about the nature of this world. And I get briefed about the desire of an enemy to hurt America. And it's a sobering experience, I'm sure you can imagine.
In a dangerous world, how far should the government go to keep us safe? From warrantless wiretapping to the Patriot Act, the Bush administration's counterterrorism policies have provoked a heated national debate. Have the administration's tough new measures been essential to preventing another 9/11? Or in its quest for security, has the administration been far too willing to sacrifice our basic liberties?
The Bush administration has violated the rights of ordinary Americans going about their everyday lives by tapping their phones without a warrant, by subjecting them to FBI demands for personal records without court oversight. There are a whole range of these practices that, looked at together, present a very disturbing view of the state of civil liberties in our country.
The question really, I think, is how do we respond as a country? Do we respond by saying, yes, we need to be safe, but at the same time we need to stay consistent to the principles upon which this country was founded? Or do we simply sort of throw in the towel, as seemed to be the case after 9/11, and let the government do whatever it wants?
But some of the officials whose job it is to keep us safe reject that kind of criticism.
That's a real false dichotomy to say it's the government and its exercise of authority in the Bush administration versus those who care about civil liberties. The fact is, this isn't Bush versus civil liberties. This is the work we're all doing together to try to keep ourselves safe.
In any given exercise of the government, when the government is looking at private people, there are risks to civil liberties. And we know that's a problem, and we know that we have to keep the confidence of the American people in what we're doing. And we try to do that in a way that is respectful of civil liberties while still allowing us to achieve our mission, which is to protect the American people.
Be seated, please.
The controversy over counterterrorism and civil liberties began to take shape just 6 weeks after 9/11, when President Bush signed the Patriot Act.
It will help law enforcement to identify, to dismantle, to disrupt, and to punish terrorists before they strike.
I think the worst thing about the Patriot Act is the name. Patriot has this Orwellian ring to it. We've actually sat down and read the bill. It is hundreds of pages of modifications and amendments to existing intelligence laws. It is really evolutionary, not revolutionary.
The Patriot Act made it easier for government agencies to share information and adapted old eavesdropping rules to the era of modern technology. But there were parts of the act that, to some Americans, aroused deep suspicion. In Connecticut, in 2005, 3 librarians and a computer systems manager decided to resist one of the most controversial provisions of the Patriot Act, one that expanded the power of the FBI.
I don't want another terrorist attack just as much as the next person, but I also firmly believe that we have to use our Constitution and the checks and balances that It provides.
What do the American people want us to do? Don't the American people want us to run down every piece of information that suggests there might be a threat against the American people? That's what we were doing, and we were doing it in the most narrowly tailored way that we could possibly do it.
The Connecticut Library fight was about something called a national security letter. It is an investigative tool created back in the 1970s that enables the FBI to demand certain kinds of records without any court order. The Patriot Act broadened the standards for using national security letters, or NSLs, to any investigation the FBI believes is relevant to terrorism.
National security letters are the most basic tool that agents need in order to conduct an investigation. So if, for example, we have information that Johnny may have some connection to al-Qaeda, there's certain things we want to know about Johnny, and we want to know him fairly quickly. We want to know who he's in communication with. So if we've got a telephone number, we want to get phone records. If we've got his email address, we want to know who he's in email contact with.
The issue is they can use these national security letters to demand information about anyone as long as they certify to themselves, again with no court oversight, that the records are related to an ongoing terrorism investigation. In legal terms, that standard is as low as it could possibly be. What it means, in effect, is that the FBI can use these national security letters to demand records about anyone.
In 2000, before the Patriot Act, the FBI made about 8,500 requests for information using NSLs. By 2005, the number had grown to approximately 47,000. One of those requests was made here, at this building in Windsor, Connecticut. In July 2005, 2 FBI agents delivered an NSL to the office of a non-profit organization called Library Connection.
I will be in the day after Christmas.
The small staff here manages a computer system that is shared by 27 libraries in the greater Hartford area. The NSL asked Library Connection to tell the FBI who had used a computer with a particular internet address during a 45-minute period back in February, some 5 months earlier. It said the information was relevant to an investigation to protect against terrorism or foreign spies.
There were 2 FBI agents. They had the letter. They had me read it. It's a one-page letter. It's pretty easy to read, and it makes it quite obvious that not only are they requesting information, but that I was bound by a gag order.
At the time, people who received national security letters were prohibited by law from ever telling anyone about it.
I could not explain that they were there, could not reveal that they were there, could never tell anyone that I received a national security letter, could never say that the FBI was there looking for information.
The so-called gag order is really a common sense aspect of trying to conduct an investigation. If recipients can turn around and tell the person whose information has been requested, hey, they're looking at you, then we've really kind of defeated the purpose of having these authorities to conduct important investigations.
In the Library Connection case, the NSL, as is standard in such cases, did not say why the FBI wanted to know who had used the computer.
The most I can say at this point is an email was sent to our government by somebody who did not identify themselves, providing information about a potential terrorist threat in Connecticut. The email is classified. I can't get into the actual details of it, but I think that gives you a general understanding of the information. But the key point here is the email was sent anonymously. Nobody put their name on the bottom. So what the FBI's primary goal, as it should be, is to try to find out who sent it.
But George Christian was troubled by the request. He knew nothing about the suspicious email, and he believed the national security letter invaded the privacy of library patrons. So in spite of the gag order, he decided to confide in 3 people he knew well, who served with him on the board of Library Connection. They were all directors of libraries in the Hartford area, who were strong believers in patron privacy.
This information is meant to be confidential, and we are the custodians. That is one of our jobs. That's one of our ethical principles, is that it needs to stay confidential. When I saw the letter, I said, well, you just have to explain to them that we don't do this kind of thing. If this is a legitimate investigation, they'll have no trouble going to a court and getting a warrant. But they wouldn't. They wouldn't do it.
It would be unheard of to impose court intervention on this kind of basic building block of an investigation, because you would simply shut down our operations.
For the librarians, the lack of a court order was not the only problem. The records that Library Connection had were not detailed enough to identify individual users. The records could only identify which library the computer had been in.
As we thought about that, I personally felt very uncomfortable because, to me, that was worse than being able to tell the person's name in some ways. It would open up, maybe thousands of people to being surveilled rather than one who might be under some type of suspicion.
The Library Connection board members decided to take the government to court, but because of the gag order, they could not tell other people what they were doing.
I could not tell anyone about the whole experience at the time. I couldn't tell my family, my sisters, my brothers, friends. I couldn't tell my boss. A boss that would be interested in knowing that you might be involved in a major lawsuit with, with the government.
ACLU, please hold.
The board members asked the American Civil Liberties Union to help them to file a lawsuit against the government.
When I first got the call from George Christian at Library Connection, I said to him that it was not particularly safe to talk on the phone in detail about the FBI's request because the gag order was so broad. By its own language, it could have been a violation for George Christian to even consult an attorney.
In August 2005, Library Connection and the ACLU filed a suit in federal court that challenged the constitutionality of NSLs.
It was a pretty daunting task. You worry about a lot of things. You worry about, losing your job. Am I going to be on a no-fly list? It's not a comforting thing to do.
They requested an expedited ruling on the one issue that to them was most pressing, the gag order.
Congress was considering the renewal of the Patriot Act, and we very much wanted to go before Congress and explain to them how the Patriot Act, or the National Security Letter of the Patriot Act, was being used. We were people that had received one, and we wanted to talk about it, but the gag order prevented us from doing that.
In September 2005, a federal judge in Connecticut ruled that the gag order should be lifted, but the judge's decision was appealed by the government, which meant that the gag order would stay in effect. Then came an unexpected twist. The name of Library Connection was supposed to have been blacked out of the court records to preserve the secrecy required by the gag order. But someone made a mistake, and soon the story of the small-town librarians who took on the FBI began to generate national publicity.
The family members were all shocked when it came out in the press. They had no idea that it was going on. And how come you didn't tell me? I said, well, I couldn't. I was gagged. Well, why would the government do that to you? They claim in the name of national security.
In Washington, where the Patriot Act was up for renewal, people began talking about the Connecticut librarians and about gag orders. Congress decided it was time to change the rules.
Congress changed the law clearly in response, at least partially, to that case.
The new statute said the need for a gag order would be decided on a case-by-case basis, and it expressly guaranteed a recipient's right to consult a lawyer.
One thing that these plaintiffs accomplished, and I give them credit for, is that the statute, as rewritten by Congress earlier this year, is much more user-friendly and much more recipient-friendly in the sense that it tells the recipient that you have certain rights to challenge this.
In March 2006, the new rules went into effect.
And now it's my honor to sign the USA Patriot Improvement and Reauthorization Act of 2005.
A few weeks later, after 10 months of enforced silence, the librarians were told that the government was lifting the gag order.
Okay, on May 31st, 2006, I don't think I'll ever forget that day. It was like a gigantic ton of bricks was lifted from my shoulder to actually be able to talk about it, to identify myself, and to be able to talk about it. It was quite an emotional day.
We have not turned down a single request to speak anywhere. We want everyone to know what's going on, that the government has given far too much authority to the FBI to investigate things without any oversight.
Eventually, though the government cannot release the details, the mystery of the email was resolved, and the FBI withdrew the national security letter.
I think people have to understand we're dealing with a threat now that's different than most of the threats we've dealt with before. We're asking more of our law enforcement agents than I think we ever have. And everybody knows in the back of their mind, do you want to be the agent who didn't connect the dots? Do you want to be the agent who thought something was a hoax that turned out to be something more?
This is not the first time that Americans have been in conflict over the balance between security and liberty, and over how far the FBI should go in dealing with internal threats to the nation's security.
The communists have been, still are, and always will be a menace to freedom, to democratic ideals, to the worship of God, and to America's way of life.
For decades, American communists and others on the political left were closely monitored by the FBI. One of its most valuable tools was wiretapping, a practice that has a curious legal history. For 34 years, from 1934 to 1968, wiretapping was prohibited by federal law. The Supreme Court ruled in 1937 that the law made no exception for the FBI. But in 1940, just before World War II, President Franklin Roosevelt made his own exception. Fearful of German spies in America, he issued a secret executive order. It said the FBI could wiretap in national security cases, as long as the Attorney General approved each tap in advance.
There was a realization on the part of the Attorney General, who has to do this review, and FBI officials, that what the President was doing was not lawful. In fact, FBI in time develops this special records procedure, and they describe the wiretaps as illegal in nature. So in a sense, there was a realization that they're really cutting corners.
The FBI carefully concealed its wiretapping activities from the public, and also its use of hidden microphones, and the break-ins its agents often conducted to install them. It was not until 1968 that Congress legalized government wiretapping in criminal cases, provided that investigators first get a court order. Just a few years later, the FBI's long record of illegal activities was brought to light by a Senate committee chaired by Idaho's Frank Church.
We heard testimony that the FBI, to protect the country against those it believed had totalitarian political views, employed the tactics of totalitarian societies against American citizens.
Thousands of Americans had had their homes and businesses broken into and had been secretly wiretapped and bugged. Among those whose political views made them FBI targets were the former First Lady, Eleanor Roosevelt, entertainers from Pete Seeger to Frank Sinatra, and America's most prominent civil rights leader, Dr. Martin Luther King, Jr.
I am not persuaded that the secret presidential orders of President Roosevelt support the domestic intelligence program. And even if it did, I do not believe that any president has the authority to order the FBI or anyone else to spy on Americans, to burgle their homes, to wiretap them, to open their mail, or to blackmail them.
I think that if we learn anything from the revelations of the mid-1970s, it is that you don't want to give the executive branch carte blanche, because the net result of this is that that power is going to be abused. And I think that what we should learn is not to repeat that, because we will, I think, 20, 30 years down the road, look back with lament at what took place.
In December 2005, a new controversy over government eavesdropping suddenly seized center stage in America, raising once again the conflicts over security, liberty, and presidential power. It centered not on the FBI, but on another government agency, the most sophisticated eavesdropping organization in the world, the National Security Agency, the NSA.
If you want to look at the comparison, the FBI engages in retail wiretapping, in other words, a phone here or there. NSA engages in wholesale eavesdropping on entire circuits that contain millions of communications at the same time.
Created in 1952, the NSA is responsible for eavesdropping on communications outside the United States. But in the 1970s, the Church Committee revealed that the NSA, on the orders of President Nixon, eavesdropped inside the U.S. on Americans who opposed the Vietnam War. In 1978, Congress enacted a law to put checks on the government's power, the Foreign Intelligence Surveillance Act, or FISA. It requires the government, if it wants to eavesdrop inside the U.S. on suspected foreign agents or terrorists, to first get a warrant from a special secret court.
What Congress tried to do in 1978 is balance liberty and security interests, and it did so by establishing a special court where submissions are given in secret, so that's not going to compromise the nation's security interests, but you're going to have someone outside of the executive branch, not acting as a rubber stamp, but making an independent evaluation.
Ladies and gentlemen, the President of the United States.
But after 9/11, the Bush administration saw electronic surveillance, especially the sophisticated capabilities of the NSA, in an urgent new light. In the fall of 2001, the president secretly authorized the NSA to eavesdrop inside the U.S. without getting warrants from the FISA court. On December 16, 2005, this top-secret program suddenly became public, reported in a page-one story by the New York Times.
The NSA story became a big one because it goes to the heart of this really historic debate that we're in the middle of over the response to 9/11 and this balance between protecting national security and at the same time protecting civil rights.
When I read that front page story, before I even finished it, after I read the headline, I was sending emails to sort of everybody within the ACLU. We got to get on the phone immediately. We got to respond. We got to figure out how to stop this. It's clearly illegal, violates clear federal law, and it violates the Constitution.
If you take the FISA court out, then you have no system at all. You have NSA being judge, jury, and executioner when it comes to deciding who's going to be eavesdropped on.
But the administration argued that the procedure for getting a FISA warrant was too slow, in an age when terrorists were switching cell phones and email addresses with lightning speed.
I've practiced before that court. You already have to have reasons or evidence as to why you should be wiretapping this particular known individual by name. Think about a world where we're facing an enemy. We may not know all their exact names and all their exact identities. We may want to search different communication streams that we think have a high likelihood to have terrorists involved. But under the existing framework, we can't do it.
The president insisted that what he had done with the NSA was legal.
As President and Commander-in-Chief, I have the constitutional responsibility and the constitutional authority to protect our country.
I think the executive branch and the presidency were designed specifically by the framers of our Constitution to take charge in moments of emergency, to take charge in moments of war, when legislatures and courts aren't really best able or well structured to respond to something like a 9/11 attack. So I don't think that the whole constitutional system's been upended, that the rule of law doesn't work in this country. I do think that we are having a political debate and a fight about the scope of government power in wartime.
Ann Beeson and the ACLU did sue the government, and in August 2006 won a ruling from a federal district court that warrantless wiretapping was indeed unconstitutional. While the government's appeal of that decision was still pending, in January 2007, the administration made an announcement. The warrantless wiretapping program would soon be coming to an end. Attorney General Gonzales said that a new arrangement for obtaining warrants had been worked out in secret with the FISA court.
We believe that the court's orders will allow the necessary speed and agility The government needs to protect our nation from a terrorist threat.
The details of the new arrangement have not been made public.
It appears to be a hybrid, somewhere in between getting an individual warrant on John Doe and saying you can grab anything you want.
But we don't know.
We don't know for sure, no.
But the debate over NSA eavesdropping is not over. Press reports and consumer lawsuits in more than a dozen states have alleged that some of America's biggest telecommunications companies have been helping the NSA. To date, none of the companies has confirmed these allegations. The New York Times published this December 2005 story, which quoted officials who did not allow their names to be used.
We know from the sources that we spoke to early on that the telecommunications companies are cooperating with the government. This was seen as a vital government effort that reached to the highest levels in terms of contact between the executive branch and the telecom industry. It's unclear exactly which companies have provided exactly what access.
What are you calling me for?
Shut up and listen. Go to the house. Go. Do not come home. Rachel Banks is dead. The papers will make it sound like I killed her.
While Hollywood's image of the NSA depicts an agency able to zero in instantly on any communication at the flick of a switch, the real NSA, though very powerful, has limits to its resources.
It's much easier for the NSA and other spy agencies to direct their resources by working with the telecom companies from the inside, by having access or at least information from the telecom lines, from the switches themselves, rather than having to grab it out of the air, in effect, from satellites.
Soon there were more press reports, including this May 2006 story in USA Today.
The debate over privacy, surveillance, and security got white hot today with the explosive front-page report that the U.S. government is keeping a gargantuan database of Americans' phone calls.
Though some of USA Today's reporting was later retracted, the story's publication created a firestorm in Washington.
For shame on us in being so far behind and being so willing to rubber stamp anything this administration does.
This is nuts. We are in a war. Look at some of the stuff in this USA Today article here. Quote, the NSA's domestic program as described by sources is far more expansive than what the White House had acknowledged. Yes, the White House is not going to acknowledge all of the things that we're doing against the enemies.
If some telecom companies had indeed given phone records to the NSA, could it have been legal? A January 2007 report by the Congressional Research Service details the many ways the government can legally obtain the phone records of individuals. But until more facts emerge, the report says, the legal status of any transfers of records the companies may have made to the government cannot be clearly determined. When the government wants to capture the contents of phone calls and emails, there are more stringent legal protections. In intelligence cases, the FISA law requires the government to get a court order that specifies a particular target. Early in 2006, in San Francisco, a retired AT&T technician named Mark Klein made an allegation against his former employer. He said that AT&T had diverted huge streams of live internet traffic and turned them over, he suspected, to the NSA.
I believe I have significant information to bring to the table on this matter, and I have been struggling for some months now to bring it out into the light of day, and that's all really that I want to do.
Klein, who worked for AT&T for 22 years, says that in this building on Folsom Street in San Francisco, on the 6th floor, the company constructed a secret room.
What they'd done, they had taken live working internet circuits, interrupted them in order to tap into them, new cables that split off the data and sent that data to the secret room. One side of the split goes to the secret room, the other side goes on to the network.
Klein says that these AT&T documents and diagrams back up his suspicions.
These are laser light signals which carry huge amounts of data. And it's domestic data, not just international data. It's all mixed up. It all goes through these pipes. Everybody's data, your email, your web surfing, your financial transactions, your video and pictures, your voice over internet, everything goes through these pipes.
Klein believes, though he cannot prove, that the signals were diverted in order to give them to the NSA.
The only person who could go in the secret room was the management level technician who had been interviewed by the NSA. We needed a code to punch in order to get in there, and only the guy with NSA clearance had the code. This shows...
Are Klein's allegations credible? Brian Reed is the director of engineering at a Silicon Valley nonprofit called the Internet Systems Consortium. He is an expert on Internet technology who has held senior engineering posts at Google, Digital Equipment Corporation, and Bell Laboratories. Reed has reviewed Mark Klein's documents and believes that they are authentic.
These just look to me exactly like all the AT&T documents that I'd seen through the years, and every detail was right. The installation that I saw documented in Mark Klein's documents is something that will tap 100% of the traffic passing through that AT&T San Francisco facility and pass it to what Klein referred to as a secret room where it can be studied and analyzed for any purpose whatever. I have no doubt that this is a wiretap setup, and I cannot imagine any other plausible use for this setup.
In January 2006, Mark Klein shared his documents with the Electronic Frontier Foundation, or EFF, a San Francisco-based advocacy group for Internet privacy.
What he told us was that after the news broke about the warrantless surveillance program, Mr. Klein rethought what it was he was doing right before he retired and essentially said, oh my God, I think I helped create this infrastructure. I think I was involved in handing people's emails over to the government.
At the time, EFF was thinking of filing a class action lawsuit against AT&T, based in part on a Los Angeles Times story that reported that the company had given the NSA access to its customers' records. Cohn retained a consultant to evaluate Klein's documents, J. Scott Marcus, an Internet systems engineer who had formerly served as the senior advisor for Internet technology at the FCC.
We basically took what Mr. Klein told us and we gave it to Mr. Marcus and we said, do you think this guy's telling the truth? Does he have a story that hangs together?
In a legal declaration submitted to the federal court, Marcus stated, I find Mr. Klein's declaration to be fully consistent with the documents and entirely plausible. It is highly probable that funding came from an outside source, and I consider the U.S. government to be the most likely source.
It's a fascinating glimpse into what might be going on, but you have to stress might. So it's an interesting theory that some telecom experts with a lot of familiarity with these inner workings believe could be credible, but I don't think it's been established conclusively.
AT&T declined our request for an on-camera interview. In a written statement, the company said, AT&T is fully committed to protecting our customers' privacy. We do not comment on matters of national security. The NSA also declined our request for an interview. Since 2006, dozens of class action lawsuits alleging violations of customer privacy have been filed not only against AT&T, but also Bell South, MCI, and Verizon. And in some places, state governments have stepped in, requesting information from telecom companies on their citizens' behalf. An effort that in New Jersey led to a confrontation between the state and federal governments.
We got involved after the papers reported that there was a widespread program being run by the NSA involving caller information. At that point, we stepped back to start thinking about the state's obligations to protect the privacy of its individual citizens. And what we found when we looked at it was that there was the possibility of a violation of New Jersey's Consumer Fraud Act. If a company's policy had given you a written piece of paper that said, we won't give out any of your call information except pursuant to court order or subpoena, and then they did turn around and do that, that would be a violation.
To find out if that had happened, in May 2006, the State Attorney General's office issued subpoenas to phone companies that did business in New Jersey. One company, Verizon Wireless, said it had not released data to the NSA. Several other companies consulted with the federal government.
They did something that I think is highly unusual in that they went to the federal government, and the federal government brought litigation against the state of New Jersey to stop the enforcement of the subpoenas.
In its brief in federal court, the Justice Department said that compliance with the subpoenas would cause exceptionally grave harm to national security. The Justice Department has also tried to block similar state inquiries in Connecticut, Maine, and Missouri.
What they've done in doing that is try to say that absolutely everything in the United States of America is homeland security, that preempts every single state from trying to protect individual rights or from states from doing anything. And I think that can't be right.
The federal state lawsuits and the consumer lawsuits against the telecom companies have all been moved to San Francisco, where they will be heard by one federal judge. The cases are not expected to be settled anytime soon.